Okay. So when we ended last class, we were talking about LAMP. Just to finish up. Okay, so where does copyright law make a distinction between anything digital and something analog? Somebody in the back.
Transmissions?
Transmissions. Oh, anywhere else in the entire copyright law?
I think not. Unless there's some weird exception somewhere. I haven't read all of the.
Yeah, I mean the only major one is definitely transmission. So if I'm giving you a CD versus giving you like a vinyl record, does it is that, what is that, by the way? What activity? Distribution. Good. And or if I'm copying a CD versus copying of a vinyl record, none of that matters. The only time it matters if you're digital versus analog is for a digital audio transmission. Okay. Let's say I want to release my own recording of American Pie. People know that song? Who wrote it? Don McLean, yeah. Yeah, Don McLean. Did he write any other songs of note? Not really, yeah. No. He has a greatest hits CD, but it's just different versions of American Pie. No, that's not true. That would be libel. Anyway, sorry. So if I wanted to release my own version, as Madonna did in 2000, what would I have to do? Would I have to go to Don McLean and get his permission?
BMI.
Sorry?
Go to BMI.
No, BMI only covers performances. But if I'm just releasing my own copy, ASCAP is also just performers.
Oh, okay.
Just they license performances. So a transmission like a radio station or like a nightclub, you'd have to go to ASCAP or BMI. But for releasing recording, what activities are we implicating? What Section 106 activities? Derivative works, very good. What else?
Making copies.
Right, reproduction, making copies, and distribution. And those are three activities that ASCAP has no power to license. The songwriters that are members of ASCAP do not give ASCAP the power to license those things. So what do you have to do if you're if you're you and you want to release your own version of American Pie? This is like part of the homework.
It is 8 cents or whatever. You can do it.
What do you say?
You can do it as long as you pay.
You can do it as long as you pay a fee. Very good. So you don't have to get permission. You just say, "Dear Mr. McLean, or Mr. Pie, I'm going to release my own version of this song. That's life." Yeah.
But you have limited moral rights, so you could presumably object if you were the songwriter and the song was used in some context you didn't like.
Really? No. Sorry. He says you have limited moral rights, so you could object if the song were used in some context you didn't like. That's just not right in America. Did you guys, when I said limited moral rights, we're talking about Section 106A, right? What does 106A say?
It's about visual art.
It's just about visual art. And I'm not really an expert in what 106A permits and doesn't permit. But it's definitely not about music. And why did we enact 106A? Did Congress, were they like, let's have some moral rights? Or was there like a concerted lobbying campaign by like painters? No, it was because we were becoming part of various treaties like the Berne Convention, which are international copyright treaties, which are actually, when you think of treaties, you think of like important ones like the Treaty of Versailles or like international mail carriage or the NAFTA, you know, but the treaties that are the most complicated are about copyright. I'm not kidding. If you go and get this book called Treaties in Force, which is published by the State Department, you go through, they've got hundreds and hundreds of treaties, and every time some ambassador sends somebody, you know, a letter that says, we agree that our jute imports will be encased in plastic instead of vinyl, you know, that's all recorded. And the state, you know, that's like what the State Department does. But they have to have a whole appendix. It's like the only appendix is on copyright because it's so complicated. In fact, the Berne Convention has never been issued among our formal series of treaties that the United States has acceded to. I don't exactly know why, but it's just like copyright treaties are like the most weird treaties. Anyway, that's it. Doesn't have anything to do with anything. Oh, so that's why we adopted that moral rights, because we were trying to adopt the minimum possible and still plausibly be members of what's called the Berne Union. Okay. So moral rights are not an obstacle to recording American Pie. And I can't believe you'd say I would do injustice to American Pie. I would, I really would respect the source material. So all I have to do is pay Don McLean, what? 8.5 cents per copy. It might have gone up, actually. It goes up like every year. And who sets that price, 8.5 cents? Is it like a free market thing? Is it by a contract? Like, where does 8.5 cents come from?
There's a board somewhere.
I think it's a revolution from maybe from the
Yeah, it comes from the government. The Copyright Office, which is part either of the legislative branch or the executive branch, depending on which branch you ask, but as part of the federal government, it just says, they declaim, the price will be 8.5 cents. It's a government set price. It's you know, it's the most centralized kind of economy you can have, just 8.5 cents. And so who is the, I mean, who are the, from an economic perspective, who are the losers with this sort of deal? The people who want to do the derivative work? Why are they the losers?
Well, I mean, it's a monopoly, right? Like, they get to set the price. So
Who gets to set the price? The government sets a price. They say, if you want to do this, you can do it without having to ask permission. All you have to do is pay 8.5 cents.
oh, I see.
Well, let's say the original
Yeah,
songwriters,
the
because
songwriters.
I mean, maybe they could have otherwise negotiated a contract for more, but now they have to deal with this 8.5 cents.
Okay, so there's songwriters, and sort of their output. Who snarfs in the output from the songwriters? Who uses songs as part of their business? Yeah, record companies would be the principal one, and they're the people who actually record the songs. And who are some other industries that use songs? Yeah, like ads and movies, right? Okay, what's becoming big money these days in the song industry? This is like a huge source of revenue now for songwriters. Ringtones, exactly. This is like huge business. Mostly because the people who want to do ringtones don't have to get permission from the record companies. Do not. No, because they're not taking like the Britney Spears version of Oops, I Did It Again. They're just like, boo, doo, 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 and you don't have to pay Britney Spears for that. Okay, so songwriters pay to these groups, and also like jukeboxes. Songwriters are sort of the, I guess maybe, I mean, we should do this a little more carefully, because before something can be in an ad or a movie, it has to come from a record company, right? So it's really the record companies who go to the jukeboxes and the, what was the other one? Ads and movies. And who else benefits from the record companies? Who else takes recordings and makes money off of them? Well, they're sort of, they work part of the record company. Yeah, radio. Okay. And then who plays radio and gets money from it? It's people like, I don't know, any store that you go in, like Sears, that might have the radio on. So there's this whole, chain here. And Congress could have let this develop sort of in a free market way, but they chose not to. Mostly because in the early 1900s, the dominant industry was not record companies or ringtones. It was songwriters. They were hugely dominant. The ASCAP and BMI were even more powerful. They're very powerful. And people would go around playing things, and ASCAP and the songwriters were, they were where it was at. And there was a new industry that wanted to get in on things, the player piano industry. And in 1908, there was a Supreme Court decision called White-Smith. The question is whether player piano rolls, if you distribute a player piano roll of a song, is that a recording of the song or is it a copy of the song? What kind of thing is it? And there was a Supreme Court decision that went one way, and then Congress didn't like the result. And so in 1909, they passed the Copyright Act of 1909, which was the major revision before 1976. And most of what we still have about music regulation, or the way that music is legislated, comes from 1909 and player piano rolls. Everybody knows what a player piano is, right? Okay. So anyway, so Congress there's not really a sort of unrestrained market here. The Congress has legislated here that if a record company or somebody else wants to get something from a songwriter, and if the song has already been recorded once, they don't have to get permission. They just pay this government set price of basically 8.5 cents per copy. It's more if the song is longer, yeah.
You call that a royalty?
Songwriters call it a mechanical, so maybe a mechanical royalty or a mechanical license fee.
Do you have, is it the Recording Industry Association of America, I don't know if I got that right, that's enforcing this? I mean, I know there's a big...
Well, the Record Industry Association, I mean, that's an association of record companies.
Right.
They...
To make sure, you know, if you're taking the song, you're paying the money, right, per copy, right?
Well, no, they're the ones paying the money to the songwriters. The songwriters have their own associations called, like, the National Music Publishers Association and the Harry Fox Agency. Those organizations represent songwriters. And there's this whole battle because historically the songwriters were incredibly dominant, and now, you know, the record industry is much more in the public consciousness. So they have started to sort of be more dominant. For instance, for things like Napster, the new Napster, and what's another one? I don't know, Rhapsody, those online services, for those to happen, the record companies had to sort of come begging to the songwriters and say, please let us put our songs on Napster or whatever. And in fact, in 2001, Universal, which is one of the 4 record labels, then one of the 5 record labels, Universal put its songs online for people to sort of, you know, to stream on demand. And it was called Farm Club. And I mean, these were Universal's own songs, was how they saw it. But of course, they weren't the songwriters. And the songwriter says, well, what are you doing here? And Universal says, well, we already paid you the 8.5 cents, so we can let people stream them whenever they want. And the songwriter's like, well, that's not covered under your Section 115 license. And they went to court, and the songwriters won. So then they had to negotiate this agreement, and it was between all of the record companies on the one hand and all of the major music publishers on the other hand about how the royalties were going to be split up for Napster and these new services. And in fact, it's still not actually decided how the royalties are going to be split up. But the record companies are paying like $1 million a year into some trust fund, and then when they finally do agree how it's going to be split up, they'll split it up. But it's, you know, a lot of these details are not worked out. Okay, so this one is sort of regulated by Congress, and then, you know, the jukebox relationship is also regulated by Congress. I don't know if you guys saw, but there's a Congress set price for that. So the record companies are sort of ripping off the songwriters, right? Do people sort of agree with me here? I mean, it's a sort of a quick and dirty way to describe it, but the record companies are not paying the market rate for these songs. Congress has set a sort of maximum price. And the record companies, you know, they strongly oppose, this is called compulsory licensing. The record companies strongly oppose compulsory licensing on their own products. You know, people say, well, you should just let all file sharing be legal, and we just have to pay, you know, $5 a month to the government, and they would split it up among the record companies, and that would be a better way of doing it than going after individual file sharers. People say this, and you know, the record companies might actually get more money if that were the case. Nobody really knows. But the record companies say, no, that is not the American way. You know, we need the power to choose whether to license our works or not. And if you have compulsory licenses for music, that will lead to compulsory licenses for books and compulsory licenses for movies. And you know, having government set prices centrally is just ridiculous. Of course, the record companies are the principal beneficiary of this on the compulsory license of their input, but they don't want a compulsory license on their output. In fairness, the record companies have more recently said, well, we're willing to give this up. But, you know, that's what they say. Okay, so on the record company output, of course, then these sort of derivative industries get to rip off the record companies, also under this congressional scheme, where jukeboxes can rip, you know, they don't have to really pay the full rate. I don't think they have to pay anything to the record companies, actually. They just have to pay the songwriters, and even that is a congressionally set rate. And radio is the worst offender. Do they have to pay anything to the record companies? Nothing. They only have to pay the songwriters. And is that a government set price? Generally not. Like when a commercial radio station pays pays ASCAP and BMI, that's, you know, it's actually kind of a government set rate. I mean, it's not set by the Copyright Act, but it is set by an antitrust lawsuit. Because ASCAP, of course, is this huge conglomerate of songwriters that have sort of come together to demand licensing, and that's not really permitted under the monopoly, the antitrust laws, and so there's all this court regulation. So in practice, it is sort of a government set rate. And if you go to ASCAP and say, and they say, okay, we want 10% of your profits, and then you can play all the music you want. And if you think that's too much, you can go to this special court in New York and say that's too much, and the court has this hearing. And anyway, but generally, this is not really a government set rate. Although for some radio stations, like college radio stations, the government does set the maximum price. Okay, anyway, and then this radio-Sears relationship, again, Sears would have to pay the songwriters for having the radio on, again by going to ASCAP. But they don't have to pay the record companies a dime, and they don't have to pay the radio stations a dime. Now, is that really fair? I mean, I don't know. But currently, the law is that radio stations don't really have any proprietary interest in the works that they're broadcasting. They don't own any sort of exclusive right to their broadcast. It's just the owners of the works. Now, there's some talk of changing that, but that's the way it is now. Okay. So people have taken economics. What's the problem when you set up this sort of highly regulated, government price-controlled relationship among all these different entities in a market? Michael?
The odds that you're in equilibrium at any point are staggeringly low.
Yeah, you're probably not in equilibrium. And if some new entity comes in here that is able to disturb this, this complicated equilibrium, then all hell can break loose. Or Napster is a bad example, but let's say MP3. All hell can break loose because these guys didn't consider they don't consider this sort of disruptive technology when they go to Congress and have this complicated system get put in place. And the more sort of brittle it is with all these interconnected links and exceptions to the exceptions and exceptions to the exceptions to the exceptions, the more brittle it gets, the more disruptive it can be for new technologies and changes. So what happened in like 1998 that set sort of the whole music world on edge that we read about in a case? The Rio, yeah. Does anybody have a Rio?
I remember them.
Yeah, it sucks.
I really
But I
wanted.
only ever bought. I think it was when like MP3 players first started.
Yeah, like
It was the very first one.
the first like portable MP3 player. So we should remember now, it's like, what, like 7 years later, right? I mean, even though the Rio totally sucked by modern perspective, to these guys it was like liquid death. They were like, oh my God. And I mean, if they had known about like the 60 gigabyte iPod that fits in your shirt pocket, the Rio was pretty big, right? And it had I think a USB 1 connector. So
Worse than that, it was parallel.
a parallel port, really? Okay, it had a parallel port, and how much memory did it have? Like 32 megabytes?
You can get 256 smart media sticks if you try really hard.
But not at the beginning, right? Okay, so at the beginning it was 32 megabytes with a parallel port, and you could put maybe one CD in low quality on, right? And it would go down your parallel port, chukka, 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 and probably people with Macintoshes couldn't use it, right? And it was 32 megabytes, and it cost how much? Probably more than $100, right? And yet it was like liquid death to the whole music industry. They were like, oh my God, and there were all these lawsuits. I don't know if the songwriters were involved, but certainly the record companies. But if they had known about the 60 gigabyte super thin iPod video, I mean, they probably would have just gone out of business right there. Let's just give up. So you should remember that when you're, well, of course, these guys did realize that they weren't just going to be dealing with the crappy Rio. That the future, if the Rio were allowed to live, the future would hold. Maybe, I don't know if they knew about 60 gigabyte FireWire iPods, but the future would be bleak in their view. So, so what did they do? Did they revamp their business model to accommodate portable MP3s? They sued, yeah. And what was the basis of their lawsuit? What was their, what would the Rio be doing that they could claim?
It had to do with the whether they were under that
It was
act.
whether it was a digital audio recording device.
Right. Whether it was a digital audio recording device. Okay. A DART. So, where does that come from? What is a DART? Has any part of the Copyright Act that we've read concerned DARTs? I just told you that the only difference between digital and analog is in transmission, right? Well, that was not really true. Why does it matter if something is a digital audio recording device?
Because then it has to use SM, what's it called?
Yeah, because digital audio recording devices are regulated by the Copyright Act. And did anybody read, by the way, the optional readings that I posted? Which one did you read?
The last one.
Which
The chart.
Oh, the fairest of the fair use one?
Yeah.
That's good. But my favorite one is Nimmer's Codifying Copyright Comprehensively, which basically, I mean, it divides the Copyright Act into two parts. The part that he calls the National Copyright Legislation, the NCL, which is sort of the parts that I assigned, and the rest of it, which I think he calls incomprehensible, which the more charitable term is para-copyright, the parts of Copyright Act that are not really about orthodox copyright. And that's sort of what we're getting into today. And one of those parts is this part about digital audio recording devices, which is called the Audio Home Recording Act of 1992. So what happened in what was the technology like the Rio that came out in 1992 that was set to ruin the record industry and destroy them? Digital audio tapes. Yeah, so 1992 saw the rise of digital audio tapes. Has anybody ever used a DAT deck? Do we now have like 60 gigabyte shirt pocket DAT decks? No. But at the time, DAT decks were thought to be liquid death for the record industry. I guess people know this quote about the Boston Strangler. Yeah. So the DAT decks were like liquid death. And why were they so threatening?
So you copy them.
You could copy the DATs, but you could copy like tapes, right? You could make a perfect copy of a DAT. And this, the copyright owners argue this was different. This was sui generis. What does that mean? Different. Yeah, of its own kind. This was totally different than anything that had come before, because with vinyl records or CDs, things would degrade. But with DAT tapes, things wouldn't degrade. You could make a perfect copy. So the record industry says, if we're going to start releasing our material digitally, the worry is that there could be a perfect copy. Now, Professor Sussman, who's an electrical engineering professor, is like, that's nothing. I can make an almost perfect copy with he has this fancy tape deck where you can adjust the angle of the heads for optimum fidelity and all these things. But in practice, it's sort of true, right? But, I mean, on the other hand, to be a record pirate, you don't really have to make a copy of a copy, right? You could just get the original record and then make a bunch of tapes from the first record. And those tapes would be, each a first-generation copy, even though you can put out thousands of them. So I've never really understood the argument that it's this serial copying that's the problem, the copy of a copy of a copy. But the record industry sees a big difference, and the ability to make perfect copies serially is very threatening to them. So they went to Congress and they said, we need regulation to protect us because we have this fragile ecosystem and we need to preserve it. They probably didn't phrase it that way. They probably got a bunch of famous singers to go in front of Congress and say, we need to keep making a living, which is a good lobbying tactic because then the Congress people get to have their arm around Madonna and So they said we need regulation, and they got it. They got the Audio Home Recording Act of 1992. And do you or I have to obey the Audio Home Recording Act of 1992? If we're building a device, would we have to obey the Audio Home Recording Act? Does it apply to just normal people who build devices, every company? Well, what was the argument? They're going after this company, Diamond, right? So yes, the Audio Home Recording Act has what's called a technology mandate. It says if you build a digital audio recording device, something that's defined with a lot of words in the Home Recording Act, it says if you build one of these digital audio recording devices, you must implement a certain technology. So we're looking here in section 1002, and it says prohibition. So this applies to everybody. No person, none at all, shall import, manufacture, distribute any digital audio recording device, which means like DAT deck or CDR deck, or digital audio interface device that does not conform to the serial copy management system. So this is a straight government mandate. They say if you build any digital audio recording device, you must implement this particular technology. Is there anything else like this in the entire federal law? I mean, I think there probably is. Although I wish I had prepared for that question. There definitely is elsewhere in the law these technology mandates. For instance, if you're a hospital and you want to provide records to the government or to other hospitals, there's a very long and complicated act called HIPAA of 1996, I think, which is like the Health Information Provider Portability Act, something like that. And that specifies these data formats, again, this particular technology. And I'm sure there's other examples. But this one applies to everybody who's manufacturing technology, this kind of technology. It says you must implement the serial copy management system. Now, how do we know what is the serial copy management system? So there's a section of this act on definitions. Here it is. Let's see what the definitions are. It tells us a digital audio copied recording, an interface device, and recording device. Recording medium, you can see how these get kind of long. Let's see. Serial copy. It doesn't say. So this is like the central piece of this piece of legislation. Maybe they say in here. No, they don't. They actually never say.
It tells you what children are, though.
It does tell you what children are, yeah. But it doesn't tell you, that's probably because you all read the Zittrain essay. Did you guys read that? Okay. So it doesn't say what the serial copy management system is. And why not?
It's a secret.
It's not a secret. It's not at all a secret. It would be kind of a problem if it were a secret and yet it's part of the law. No, the reason they don't tell you, in fact, late versions of this bill, when it was in Congress, did contain the serial copy management system. They told you all the technical details. But Congress was very concerned that they did not want to mandate a particular technology. They thought it would set a bad precedent for the U.S., because they want to have free markets and these kinds of things. And Congress generally does not like the perception that Congress is centrally deciding on technology for the whole country. So they did not want the idea that Congress was setting out a technical standard by putting a technical standard in the law. So they removed the definition of serial copy management system from the law. And they put it sort of in some ancillary documents that are like, well, what we meant was this. But it's not part of the law. And in my view, of course, they're still mandating a particular technology, and it only makes it worse to then not actually specify what it is. Does anybody disagree? Does anybody want to take Congress's side?
Well, then they can update it more, like if a new format comes out, they can.
Seems like it could change
That's
it
what
all.
3 is for.
Right.
Any other system certified by the Secretary of Commerce? Well, that's true. But I don't see why if they're going to mandate the serial copy management system, I don't see why they couldn't. Yeah.
I would approve it if it has been precise where you can find the serial copy management system or what organism should issue the regulation.
Yeah, I don't. As far as I know, it is not actually. I don't think they ever tell you.
It's problematic that they don't describe it, because what if somebody say they did implement it, but I mean they could just say whatever it is that might be the serial copy management system.
It could be problematic. Yes, I agree. It's problematic. Anyway, and then anybody who does make, so what does the serial copy management system actually do?
Prevent second-generation copies.
Right, it stops you from making a copy of a copy. So when you put in a DAT tape, the DAT tape will say this is an original, or this is a copy, or this is a copy of a copy. Or maybe it's just original or copy. But either way, it won't let you make a copy of a copy. And when a DAT tape is connected digitally to any other DAT deck, it'll tell you whether it's a copy or a copy of a copy or an original or whatever, and it'll increment that counter, and it just will not let you make a copy of a copy. What if you own the copyright on the recording? Well, then will it let you? Like if it's your own band? No. I mean, it wouldn't. Because otherwise you could just be like, yeah, I'm the copyright owner on Oops, I Did It Again. And so even if it's your own recording, it won't let you make a copy of a copy. And this, among other things, basically killed DAT as a format. And this also applies to CDR decks that would go like in your stereo. It doesn't apply to computer CDR drives, but it applies to CDR decks. And it applies to the music CDRs, the CDRs that are marketed for music that have like the word music on them. But it doesn't apply to data CDRs. And in fact, the record industry probably wanted this act to regulate computers, but they had to compromise, and so they said, okay, we'll exempt computers, because in 1992, everybody knows computers not really fast enough to handle the full audio stream from a DAT, so we don't need to worry about them. That proved to be a short-sighted decision. Anyway, and then furthermore, people who manufacture these DAT decks and the DAT media and the music CDRs, they all have to pay a tax that goes to the government. It's like a 2 or 3% tax. And the idea is to compensate copyright owners for the losses that they're getting from these first-generation perfect copies. And the law specifies in exacting language that 55% of that money will go to the record industry, and 45% will go to the songwriters, and a certain percentage will go to the backup singers in that are not listed on the CD booklet, and it's very specific. But then in exchange, the record industry agreed to give immunity to other kinds of devices. They said, okay, in exchange for getting this licensing and technology regime for digital audio recording devices, we are going to agree never to sue anybody and not to be able to sue anybody for their analog copies, their personal, non-commercial analog cassette copies, and their personal, non-commercial digital copies, for that matter. So if you make a first-generation copy with a DAT deck that uses the serial copy management system, that could be an infringing copy, right? But the copywriter said, okay, fine, put in the law that even if it is an infringing copy, those people are going to be immune from suit because, of course, we're getting this tax. So sort of in exchange from the tax revenue, we are going to make these people immune. Now, does this let you copy things on the internet? Did the internet really exist in 1992 as far as Congress was concerned? Not really, no. Yeah, I mean, the view of most modern commentators is that if you make a copy onto a music CDR, that is immunized. So if you pull something down off Napster and sort of immediately burn it onto an audio CDR, and by Napster I mean like Grokster or Kazaa or i2Hub. If you pull something off the internet and immediately burn it onto a music CDR that says music on it, most people think that that's okay. Not that it's okay, but that it's immunized, that you can't be successfully sued for it. But nobody really knows. But anyway, that's the Audio Home Recording Act, and that is this sort of mandate style of regulation where Congress says, you will use this technology. Another example would be like the FCC. When they say you broadcast television, they don't just say broadcast television however the hell you want. They say use the television standard, the NTSC standard. Okay. So that's the sort of underwork for the. So that was the Rio case. And what was the question in the Rio case? Who can put in one sentence the question?
Is the Rio a digital audio?
That's basically it. Is the Rio a digital audio recording device? Because if it is, they have to be paying these royalties and everything, and they have to be preventing the serial copies. And what was the court's answer? No. And was the court's answer, do you think that you could have gone on the same sort of reasoning process? It was all about what is a digital musical recording? Is it the whole hard disk? Or can a file be a digital musical recording? And by the way, is a digital musical recording, we talk about phonorecords. What's a phonorecord?
The actual recording in its physical form.
Yeah, the actual disc is a phonorecord, like a vinyl record or a CD. That's the phonorecord. What's a sound recording?
That's the information stored on it.
Right. A sound recording is like the work. Like if we talk about like Moby Dick, that's the work, and the sound recording is the work. But then you could have like a copy of Moby Dick or a phonorecord of Britney Spears. So the phonorecord is a material object. And then, but in the Audio Home Recording Act, Congress adopted this whole sort of parallel language, like digital musical recordings, because they said they didn't want to disturb the existing meaning of phonorecord. So they had this whole sort of parallel. I mean, this Section 1000, Chapter 10, it doesn't really interact with the rest of the Copyright Act. It's just sort of out there. And they have their own definitions, their own terms, and mostly it means that Congress either didn't really know what, well, the lobbyists who developed this law, you know, they wanted to just have it exist by itself and not really, either they didn't want to have to worry about phonorecord and all this old copyright law stuff. They just made this whole separate regime. So this is why Nimmer would call it outside the sort of national copyright legislation. But it is part of Title 17. Okay. So so was the Audio Recording Act like a success from anybody's perspective? I mean, it did sort of kill DAT. But was anybody really happy with the result? I mean, the record industry wasn't really happy because, you know, it didn't stop things like the RIO. You could sort of get around this technology mandate. And I don't think engineers like being told, like, you must use a certain technology. So, and it didn't apply to computers, which was maybe the biggest failure. Because, I mean, how could you have a technology mandate apply to computers? It would, I mean, how would it work? Well, you define a computer, but then who is responsible for making sure that the computer obeys the mandate? I mean, does it apply to software and our users? Would users have to be prevented from writing their own software? I mean, it's difficult to see how you would enforce this.
It's easy.
Yeah, I mean, you might have to change. When we think of a computer, like now you can build one yourself. You can buy the video card from one company and the motherboard from a different company, and you can write your own software. I mean, that might all have to change if you wanted to have some enforced technology mandate for computers. And Congress is not willing to do that in 1992. Also because, you know, which industry is bigger? Like the consumer electronics and computer industry or the copyright owning industries? Yeah, I think the consumer electronics by far dwarfs the copyright industries. Of course, they may be all foreign. I don't know. Anyway, okay. So it doesn't apply to computers. It didn't really work very well. So in the mid-90s, the copyright owners got a new idea. They say, well, you know, we're really concerned that the Copyright Act is not going to support our new business models. Like we might want to have, you know, encrypted satellite television where we deliver to you the entire, you know, all 400 channels, but they're all encrypted, and you have to pay us, you know, to decode a particular channel or maybe even a particular show, and we don't want, you know, we're worried that there's going to be these black boxes that are going to be able to decode satellite television without people paying us. And would that be copyright infringement? Well, let's talk about like satellite television. Would that be copyright infringement to, if somebody gave you a black box, sold on the market a black box that let you descramble satellite television without paying, would that be copyright infringement? Would it implicate any of the activities of copyright? Reproduction, distribution? No, it's just sort of reception. So it wouldn't. Now, it turns out there are other laws about theft of services that it would implicate, but not the copyright, not copyright infringement. And they say, and how about this? We want to give you a DVD that has a CD that has 1 million fonts on it, you know, Garamond and Times and Courier and Helvetica. And we're going to give you all these fonts, but they're all going to be encrypted. And when you want to get one font, you just pay us the money, and we'll give you the decryption key for one font. But we're concerned somebody might distribute a black box that will let you decrypt all the fonts, and that would ruin us, or at least it would ruin this business model. So, and would that be copyright infringement? Would it be anything illegal? You think it would be theft? I mean, literal theft, you have to like steal something that belongs to somebody, like steal actual property.
Yeah, but you're stealing the use of something being paid for, aren't you?
What would they give to you that did before? Is it the same thing?
Is it the same thing? I mean, you know, there's laws about theft, and they generally don't apply to things like copyright infringement. So it's hard to see that they would apply to that. But what other legal tools could the providers of these font CDs use?
Well, there could be a shrink wrap license on the font CD.
Yeah, there could be a contract between you and the font people that says, I will not decrypt these fonts unless I've paid you. And that would probably work. But what are the problem with these contracts?
You cannot control all consumers.
You can't control everybody. Why not?
If you have 1 million consumers, and then you have someone who proposes software able to do this primarily, you cannot control all 1 million of consumers checking if they don't use it.
Okay, so that's a problem. The contract might apply to all the people who've actually bought the software, but it doesn't apply to these distributors. Just like the Copyright Act certainly applies to the people who go library building by downloading all the, or not downloading, recording all the episodes of 24 when they're on TV and saving them. That's illegal, and the Copyright Act reaches them, but it does not reach Sony that distributes the machine that makes this all possible. So here, Damien says that the Copyright Act, or the contract, might reach those people who actually rip off the fonts, but it wouldn't reach the people who are making that possible, who are distributing the technology. So that's problem one. What's another problem with contracts? Are they legally binding?
Yeah, like if I say like, oh, I bought this, but I don't really feel like doing that contract, so I waive my warranty or whatever. Am I supposed to obey whatever it says on the package?
Are you supposed to obey whatever it says on the package? Well, that turns out to be an incredibly difficult issue. And it was an incredibly difficult issue before, and now that these questions are becoming more and more entangled with copyright, it's beyond difficult, because contracts are a state issue, and different states can have different laws about what kinds of contracts are permissible. Copyright is a federal issue. David Nimmer is the world's expert on American copyright law, and Raymond Nimmer is a big expert on shrink wrap licenses. And when you get the two Nimmers involved, it's just a horrible mess. It's like having orange and lemon in the same dish. It doesn't work. So anyway, it gets incredibly complicated. So, that is people's fear about these contracts, that even if they were largely enforceable, you could have all sorts of problems. Like if somebody who's 16 years old agreed to the contract, well, there's all this stuff about young people may not be able to, agree to a contract. Or what if somebody might get the contract and then give the disc to somebody else? And that's legal under the first sale rule, right? And that new person might not be bound by the contract. So anyway, it becomes, for various reasons, the providers are not confident that contracts will preserve their rights. So they say, we need a new law to support these business models. We need, in our language, we'd say we need new exclusive rights, because the ones that we've got are not good enough. Now, what was the, and they had a further argument, because in the mid-90s, there was a new technology coming out. What was that? There was a big rallying cry in the election of 1992 that the new presidential administration was going to develop this new technology.
The internet.
Well, they didn't call it that, though. What do they call it?
Information superhighway.
The information superhighway is what it was called. And Al Gore everybody was talking about the information superhighway. And once they got elected, this happens to a lot of presidential administrations, but things get a lot more sober when they get elected. Like President Bush says, and we're going to have regulation of carbon dioxide emissions. And he got elected and he tampered that down. And, you know, Hamas has said, we're going to kill everybody in Israel. And they've got elected, and actually nobody knows if they're going to tamper that down. But anyway, one hopes that when regimes get elected and have to do actual governance, that they tamper things down. And so the Clinton administration, with all its exuberance, they tampered it down, and they stopped calling about the information superhighway, and they called it what? It was the National Information Infrastructure, the NIE. I like the old name. Anyway, and they had all sorts of, you know how the Clinton administration was. They had working groups and focus groups and sessions and meetings, and that's just how they were. And they had ones about this, and the copyright owners were there, and they says, look, you know, to put our works on the internet, you know, unless we're not going to have Time magazine on the internet or music on the internet, or you know, the New York. We're not going to put these works on the internet unless you give us added protections. And you're just going to build all these pipes in the national information infrastructure. You're going to build all these pipes, but they're going to be empty because we will not put our works online unless you give us added protections. Now, do people believe that? I mean, nobody really knows. It's kind of a bargaining chip. It's true that by the mid-'90s and the late '90s, certainly, the major copyright owners were already putting their content online without protection, you know, without these added protections. And they did already have copyright. You could be like, what more do you need? But that was sort of the argument. And there were all sorts of documents. There was the green paper and the white paper and various laws. And they were ultimately not really successful in Congress.
Are they protected now?
Well, we'll get to that. But the sort of lawmaking process that came out of the national information infrastructure, the new rights that they wanted, were not, Congress didn't pass them. And so they took a different strategy, which is to say, look, our works are being ripped off by people in other countries. And, you know, we might distribute these encrypted whatevers, and people in other countries are going to rip them off. And we want the whole world to agree on a new copyright treaty to prevent us from getting, you know, to give us new rights globally. And so they had this whole treaty process with an organization that was called. Anybody know how this is pronounced? It's actually WIPO, the World Intellectual Property Organization. Because they had I'm going to screw this up. They had an old name. I wish I remember their old name. But in English, like the acronym was like dumb shit or something. Like it was. They didn't, you know, it's an international organization. It's in Geneva, Switzerland, and there's all sorts of people coming together. But they didn't like that in English people would call it this bad name. And I don't remember the original name. So they changed it to World Intellectual Property Organization from whatever it had been. And then they were, you know, immediately annoyed. I guess they didn't realize, but all the Americans started calling it the WIPO. But they were like, no, it's WIPO. So it is apparently WIPO. And that actually, you know, one of these board, you know, the prices for the 8.5 cents, there's a lot of those in the Copyright Act, and one of them is set by a group that was, or used to be set by a group that was going to be called the Copyright Royalty Arbitration Tribunal. But Congress was careful, and so they decided to call it the Copyright Arbitration Royalty, it's panel. Copyright Arbitration Royalty Panel. Well, I blew that one, but it's a Copyright Royalty Arbitration Panel, but they don't call it that. So anyway, so in the WIPO, they had these negotiations, and they agreed on something called the WIPO Copyright Treaty, or the WCT for short. And the WIPO Copyright Treaty, treaties are written in sort of very broad language, and it says member states will protect blah, 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 blah. But it says member states will protect if their works are subject to access control on the access, that will be protected at law. Now that's sort of a new word, right? Access. Is there any protection on access in the Copyright Act now? I mean, by now I mean 1997. No, there's distribution, reproduction, derivative works, performance, display, but there's nothing on access. So there's nothing bad about accessing those encrypted fonts or on accessing the encrypted satellite TV, at least not under the Copyright Act. So they said, we need new control on access. And that's what the WIPO Copyright Treaty, the countries that ratified that pledged to grant that. And of course, the protections of the WIPO Copyright Treaty are only available to nations who have themselves adopted the WIPO Copyright Treaty. So for instance, American works would only gain the protections of the WCT abroad in Europe if America had ratified the WCT. So there's definitely an incentive for us to do it, especially because America is like the world's major exporter of copyrighted works. Probably us and then India. Who do you think is probably third? I have no idea. But I think certainly in movies, I think it's us and India, and I don't think there's really, I don't know, maybe probably Japan. I really have no idea. But so that was another incentive. So anyway, the Clinton administration decided to ratify the WIPO Copyright Treaty, because then America would gain these protections worldwide, at least among all the other countries that had ratified the WIPO Copyright Treaty. And so we did ratify it in the fall of 1998, 6 years, actually the same day. It was October 28th, 1998. 6 years after they had adopted the Audio Home Recording Act. And even though basically very similar measures had failed in Congress in 1995 and 1996, once they were part of an international treaty, and it was sort of a take-it-or-leave-it situation. In 1998, Congress adopted them by passing a law called what? The Digital Millennium. The Clinton administration was really big on those millenniums. People remember? Everything was about the new millennium. The Digital Millennium Copyright Act of 1998. And this, for the first time, it sort of added a new exclusive right. Not for the first time, but it added a new exclusive right to the Copyright Act of sorts. And it's sort of an exclusive right to control access to a copyrighted work. So we can look at what it says. Oops. Okay. So this is what I've got chalk up my nose, I'm sorry. But this is what it says. Digital Millennium Copyright Act. So this is section 1201, again sort of outside the Copyright Act sort of ends at maybe 600, I would say. But 1201. I mean, it doesn't literally end there, but the National Copyright Legislation. 1201, A1A. No person, so again, this is a law that applies to the whole world. No person shall circumvent a technological measure that effectively controls access to a work protected under this title. So what does that mean? We got a lot of terms here, just in one sentence. This is basically the whole law. Of course, it goes on for like 30 more pages. But okay, so we have to ask, what is circumvent? What is technological measure? What's effectively control? And then there's that word access. And then work protected under this title. The last one is easy. What's a work protected under this title? What's this title? Copyright Act. It's Title 17. Okay, and what is... okay, so then we go down, and it tells us... Okay, as used in this subsection, to circumvent a technological measure means to descramble a scrambled work, to decrypt an encrypted work, or otherwise to avoid, bypass, remove, deactivate, or impair a technological measure without the authority of the copyright owner. So it means, so to circumvent it is to do any of those activities unless you are authorized by the copyright owner. And what does it mean if a technological, what is a technological measure, by the way? That would be like the encryption on the DVD or on the cable TV. A technological measure effectively controls access to a work if the measure in the ordinary, you can see how like there's all sorts of fodder for people to argue about here. In the ordinary course, this is like my entire freshman and sophomore year was arguing about this. So, in the ordinary course of its operation, requires the application of information or a process or a treatment with the authority of the copyright owner to gain access to a work. So this is really hard. It's really hard to know what all this means. And it doesn't help that they go on, at great length about this. But what do people think that Congress was probably getting at here? First of all, how do we explain this kind of regulation? What kind of regulation is this? Is it this kind of regulation? Is there a technological mandate?
You can't do this versus you have to do it.
Yeah, there's no technological mandate. And the sort of forces of anti, like a group called the Home Recording Rights Coalition, which is paid for by consumer electronics makers. It's all about home recording. They were very concerned that there be no mandate on the technology companies. They said this law should not apply to us in the honest course of our business. We should be able to design our DVD player however we like, or our our computer however we like, and you shouldn't tell us we have to implement some form of copy protection. We have to look for, in the Audio Home Recording Act, you have to look for some flag that's getting sent to you that says that you can't let the user copy this anymore. And if the flag says no more copies, you cannot allow any more copies. That's what the law says. That's what the serial copy management system does, and you have to obey that. You have to build that into your technology. The Digital Millennium Copyright Act, it's not like that. It has no mandate. If you're building let's say you're building Adobe Acrobat Reader, and the Adobe Acrobat file, the PDF file, has a little flag on the top that says the user cannot print this file, and you're writing that software. Do you have to obey that? If it says printing forbidden, do you have to obey that? If you're writing, an Acrobat Reader? Yes? Why?
Well, it says you can't copy it. I mean, you can't print it, and that's a technological measure which prevents you from accessing the printed word when it's based.
Yeah, I mean, so what's a technological measure? To circumvent what's forbidden is circumventing. And to circumvent means to descramble, to decrypt, to avoid, bypass, remove, deactivate, or impair a technological measure. What does it mean if a technological measure effectively controls access? It means that the measure, in the ordinary course of its operation, requires you to put in information or a process or a treatment to get access. Is that little message that says no printing permitted, is that really a technological measure? Well, do you say yes?
Well, if the thing is just a message and you can still print it by just going and hitting the print button, then...
Well, no, but you are writing the software. And Adobe puts something in their specification that says, if it says no printing, the software writer must forbid printing. That's in the specification.
That's probably not covered in it.
Okay, yeah, Michael?
Yeah, but what if it says no printing without this encrypted password?
What do you mean?
Like, what if a PDF file requires the use of a password to print it?
Like, how would that work?
I don't know. I've never looked at how the PDF files work, but suppose that you wrote a format that did work that way. Would writing a reader that ignored that be a problem?
Well, it's a hard question. We have to ask if it effectively controls access to the work. I mean, what I would say is if the software can get enough of the PDF in order to render it on the screen without needing that password, then it doesn't seem to me that the technological measure effectively controls access to the work. And if the software is happy to print the part of it that it can render the screen without the password, seems to me that's not circumventing anything. So it's not like the Audio Home Recording Act. It doesn't say if this flag is present, you must look for it and you must design a circuit to look for it and obey it. It's not like that at all. It says it's not the job of the device manufacturer to control the copying, which it is in the Audio Home Recording Act. It's the job of the person who publishes the work to put this technological measure on it to control the copying. So the responsibility is not, it would have been smart to have some clever diagram, but the responsibility is not on the consumer side to obey some instruction. The responsibility is on the publisher's side to put this technological measure on it to stop you in the ordinary course of its operation from doing whatever it is they don't want you to do, gaining access, without something extra, some information, some process, or some treatment. And if they put that on, then yes, you can't be all clever and use your education to circumvent it. But it's their job, at least initially, to stop you. So is this, do people have any thoughts on this way of regulating? I mean, is this preferable to saying if you're making the PDF viewer, you have to look for that flag?
It's more ambiguous.
More ambiguous. Yeah.
It's hard though. I mean, how do you expect to write your program to expect any type of things to obey? Like, what if it's not just printing? What if it's like other things as well? And it seems so hard to write a program to do that.
Yeah, well, and in here the DMCA doesn't really put any obligations on the person who's writing the sort of viewer, the receiver. That person just has to do whatever they would normally do, and it's the job of the publisher to put on a technological measure that will ordinarily require something extra. Like that could be like an encryption key for a DVD, or the people have like DirecTV. DirecTV, you have to have like a little card, right, for it to work. Okay, so but you guys many of you are majoring in course 6, right? What are some of the problems with this approach? First of all, do these technological measures exist? Like, what is a technological measure? Do they exist? Okay, like what?
Like DVDs have some form of encryption.
Yeah, that's going to be my good example of something that's a very tricky case.
They work well, but they exist.
Yeah. Okay. I mean, what is the contemporary term for these technological measures? What do people call it? DRM. This is a pretty new term. What does DRM stand for? Digital rights management. And does it? Okay. And can somebody explain how DRM works, like on a computer?
It's like kind of common to people that you can only say you can't move that file to a different computer.
Yeah. And how does that work?
Secret.
It's a secret. How do computers work? Like when you get a program, is the way it operates like a real secret?
You can disassemble it.
I mean, what is a computer program, right?
Instructions.
It's like a list of instructions to the computer. So how would you keep a secret about how iTunes works?
By making sure people don't tell other people.
By making sure people don't tell other people. Okay, but when Apple has to publish the software, right? So they sort of do tell everybody.
They just do encryption.
They use encryption. How does the encryption stop you from learning how it works?
Can't decrypt it. It's gibberish.
If you can't decrypt it, that's gibberish. That's true. But we're talking about the program, right? You can't get the source code. That's true. But you can get the computer code, right? The code that the chip uses. And the chip can decrypt it, right? Somebody's got to be able to decrypt it in order to use it.
But the user's not supposed to see the decrypted version.
The user's not supposed to see the decrypted version. That's true. But
Theoretically, you can still break it, like third-party software.
I mean, is there like a class at MIT where they teach you how to write a computer program that can be run but not looked at?
6001.
6001. Oh, very clever. I asked Hal the guest lecture today, but he's like, I don't know what he said. He said no. But what does it say in the 6001 book about what is the purpose of code?
People can read it.
People can read it, but what else do they say? Well, yeah, so people can read. It's also for a computer to read, right?
Yeah.
But it's but people to read it. And this is what we teach in the first day of computer science, which they also say. Also say in the first page of the 6001 book? It's not about computers and it's not science. That's what it says. Okay, so so is there a class at MIT how they'll teach you the reverse of that, that you can write a computer program that computers can read but people cannot? Where do we learn how to do that? 6004. How do you do it?
Well, you can write numbers, just like the native code of the CPU. And yeah, I mean, you can still read it. It's just going to take you a very long time.
It would take you a long time. Yeah. I mean, this is a pretty nascent field, and it's not really what you would call like a legitimate field of engineering yet. I mean, there's no classes in it. There's nobody who's really an expert on it. There's techniques that people use. One of them that's very good is to have some extra chip that's outside the processor, and that's the chip that actually does the part that you're concerned about. And then the chip can be sealed in, the best kind are sealed in like sulfuric acid, and if you try and break open the container, it melts the chip. Those are awesome. And in fact, you can get the Encyclopedia Britannica on CD-ROM, but the CD-ROM will be encrypted, and you have to plug in a little dongle to the keyboard port, and the dongle has the encryption key. And if you try and break it open, sulfuric acid, melts the encryption key. So that's a good example of DRM that, I mean, that's a good technique that you can't look at it because sulfuric acid will melt it. On the other hand, for Encyclopedia Britannica, eventually the computer, gets to see the page of Encyclopedia Britannica. So you could write some sort of bad thing on the computer. Now maybe the encryption key makes you only be able to look at one page every 3 hours or something, so you couldn't do it very quickly. They can stop you there. Or maybe the encryption key, the dongle has its own monitor built in, and somehow they stop you from taking a picture of the monitor. I mean, it gets very tricky, yeah.
I think the principle is to prevent copying with a reasonable amount of effort, right? Like you can probably do copies if you spend years doing it.
So a lot of people raised these concerns, and the content industries replied, "We're not out to stop the Chinese. There's a big problem for the Chinese bootlegging, and you can go to. My dad is a big fan of movies, and he went to Beijing, and he got all these DVDs, and he brought them back for me. Like, Dad, these are bootlegs, but he's like, it's so cheap, But anyway, so a lot of people raise these objections. Said, look, DRM, it just doesn't really, at least in a computer, doesn't really exist. Yes, you can build a DirecTV receiver that's sealed in sulfuric acid, but that's not going to stop you from copying the movie once it gets out of the receiver. And yes, you can build a little dongle that's sealed in sulfuric acid, or a DVD that's encrypted, but that's not going to stop people, if you make a computer able to decode DVDs, that's not going to stop people from learning how that works, because code is not just instructions to computer, it's instructions to people as well. And they say, well, we know all that. The movie industry said, we got a lot of money, and we got a lot of smart people too, but this is not going to stop the Chinese bootleggers. All we're out to do is to keep the honest people honest. That was sort of the refrain. And they say, if we can make it just difficult, that's good enough, because that will keep the honest people honest. Now, what's one of the problems with this sort of line of thinking? Yeah?
If they're already honest, then why do you need to keep them honest?
Yeah.
Okay, that's true. If they're already honest, then what? But I mean, people here are basically honest, right? Wouldn't you say? And who here has never traded a song or gotten a song illegally on the internet? One person. Do you want to be on the camera as like the exemplar of MIT? No, okay. Have you ever broken copyright at all in your life?
I'm sure I have.
Okay, but not online?
I don't listen to Danish music.
Okay. So, but the entire rest of the class, including me, have all broken the law, even though we're all honest. So the copyright owner says, look, if we can just make it a little harder, have a little speed bump, then you'd be more likely to go buy it legitimately. You could go to the store, you could get it on Amazon, or now more recently you can get it on iTunes or the new Napster or whatever. But what's a problem with the keep the honest people honest? Yeah.
What happens if you have someone who figures it out and just makes it easy?
Yeah, that's a real problem. He says, what happens if one person figures it out? Because the internet, it's sort of Lawrence Lessig points out. Was this in the Zittrain essay as well? I hope it wasn't, because then it can look like my idea. But the internet is sort of an amplifier for, rogue people. And if just one guy figures out how your digital rights management works. By the way, does digital rights management, does that protect rights under the copyright law? I mean, it's not about like distribution or publication or display or performance. It's often not even really about access. It's sort of about things you can't do, even though the law would otherwise permit you. And critics have adopted the term digital restrictions management. I just often call it like painful stuff, because anyway, it makes things hard. But so yes, the internet is like an amplifier for rogue people. And for the new Britney Spears CD, even if every copy of Britney Spears had been locked down and not easy to copy, only one guy would have to do it and put it on the old Napster or Kazaa or Grokster or iTunes or whatever. It could be some guy from Vanuatu where they don't have laws. And suddenly, once there's that one unlocked copy, it could go all around the world. And suddenly there's no more speed bump for the honest people. Or, yeah, the mostly honest people, largely honest people. So that's a big problem. So what did they say? Okay, well, we're going to have a second level of protection. We're not just going to stop people from getting around the DRM. Who else are we going to stop? Yeah.
People who like distributor put links about how to implement the DRM.
Yeah, so that we're going to attribute the second level people, the Sonys. Of course, at this point, it was Sony, the movie studio, who was like, yeah. But we're going to get the second level people, the people who distribute help in circumventing technological measures. Now, can they get people who distribute like instructions? Like if Wired magazine is like, here is how to descramble a DVD or something. Can they get those people? The Wired magazine, the New York Times? Yeah, the First Amendment is a problem. So you can't just, can you put bomb-making instructions in the New York Times? Like, here's how to make a Molotov cocktail. Is that a bomb? Or just like...
No, you can. It's not protected because First Amendment doesn't protect instructions to do illegal stuff.
He says the First Amendment doesn't protect instructions to do illegal stuff.
Well,
Sure. Well, that's what they said in the Korea case.
In the which case?
In the Korea against the...
Corley. Yeah. In general, the First Amendment does protect instructions to do illegal stuff. You can even write like, I think it would... I'm not going to say that. But okay, let's talk about Hamas, which was a political... I don't know what they are, but they were recently elected to be in the majority government of the Palestinian Authority. They regularly write things like, we should kill everybody in Israel. And that would, let's say they were in the United States, that would be illegal, right? Yes, it would be illegal. But if they published in their newspaper, we think as a political measure that it would be a good idea to kill all the people in Israel. Is that illegal? Can the United States ban that kind of expression? No. And in fact, there's domestic groups like the KKK, which is not really longer a major force in American politics, but they, write things like, we want to, actually don't know what they write, but I'm sure it's bad, whatever it is, and illegal, and it's protected. It's protected speech. Now there's some limits, like like if there's an imminent danger of incitement to lawless action. So if you're out there and there's like the whole Ku Klux Klan with is the Ku Klux Klan or anyway with their hats and the whole deal, and you're like, okay, go. If you're like that, then yes, there could be some. It could be illegal, but if there's this imminent danger of lawless action, and there's some other exceptions, like things that are. Well, there's a lot of exceptions. There's threats, like if you're like. there's that too. There's shouting fire in a crowded theater, but there's also like, I'm gonna kill you. You know, there's or burning a cross on somebody's lawn. In many cases, is not protected by the First Amendment. These sort of inherently threatening actions. There's also libel, is not protected by the First Amendment. If I write, you know, Kevin Chen kills little babies, you know, that's not protected by the First Amendment. What's some other exceptions? What about burning the American flag in public? How about that? Is that protected? Yeah, it actually is protected. I mean, for many years in America's history, it was not. But then in 1989, this guy in Texas was like, I don't know if he said anything, but he burned the flag, and it went to the Supreme Court. There was a law in Texas against burning the American flag, which is a very emotional issue. And it went to the Supreme Court, and they ruled, I think 5-4, that the Constitution prevented a state from banning flag burning. And then what did Congress do in response? Did they pass a constitutional amendment?
They tried.
I think they may have tried. It didn't make it through Congress, and so they just passed a federal law that said, like, the exact same thing that the Texas law had said. And that went up to the Supreme Court the next year, and again in a 5-4 ruling, the Supreme Court ruled it unconstitutional. And now, of course, Congress is very close to passing a flag-burning amendment, which is, you know, of course, is only part of the constitutional amendment process. But the House is overwhelmingly in favor, and the Senate is like 2 senators away from wanting to pass a flag-burning amendment. So it could happen. But right now, you can burn the American flag all you want, if it's, you know, your American flag, and unless the fire is going to set fire to something else. What are some other exceptions to the First Amendment?
Obscenity?
Yeah, obscenity. And what did obscenity used to be? I read a paper, by the way. It was the Melville Nimmer lecture. Melville Nimmer was David Nimmer's father, and he started this book, Nimmer on Copyright. And he was also a famous First Amendment attorney. And he litigated this case, Cohen versus California, in the Supreme Court. Do people know what that was about? Well, this guy in California, which was at that time an oppressive regime in the West, he went into a county, this is in the 60s, probably the late 60s, during the Vietnam War. He went into a county courthouse with a jacket, and the jacket said, "Fuck the draft." And he was arrested. Actually, the sheriff in the courthouse was like, "You better take that off." And then the sheriff reported him to the judge to be cited for contempt of court. And the judge was like, "I have better things to do." And then as the guy was leaving, the same sheriff arrested him himself. Anyway, for public indecency or obscenity or something like that, it went all the way to the Supreme Court, and they ruled, I think like 7-2, that it was okay to say "fuck the draft," and that no state could prohibit you from wearing that on your jacket in a county courthouse. And the justice, the New York Times covered this case, and they always love to talk about the Supreme Court, and they never once used the word "fuck." In fact, that word has only appeared one time in the entire history of the New York Times, when they printed the Starr report about President Clinton. But anyway, so and there are exceptions to the First Amendment when it comes to obscenity, including very hardcore pornography, and that's basically it. And another one would be child pornography, which is not obscenity but is also not okay. Okay, and another one is this sort of it's speech that is tied up in conduct. So the Constitution, the Supreme Court says you can prohibit conduct like hitting people, and you can't prohibit speech. But what if you do something that is sort of inherently both? For instance, burning the American flag, we say, is speech and is okay. But what about burning your draft card? Because there's a law there used to be a law that says you have to have a draft card, to be in the Vietnam War. And this dude, I think Mr. O'Brien, he burned his draft card as part of a protest. And is this protected? No. Why not?
The government uses it for tracking purposes.
Yeah. Yeah, I mean, I think I mean, there's this O'Brien case, which is about when can you ban speech that is tied up with conduct, and it's about is the regulation directed neutrally at the conduct and not at the content of the speech, and there's these various tests. Anyway, so here we're talking about keeping the honest people honest, and we've said it's not enough just to stop people from circumventing. We also have to stop people from helping people who circumvent. And so there's the second part of the DMCA. The first part is no circumventing. And the second part is no person shall manufacture, import, offer to the public, provide, or otherwise traffic in any technology, product, service, device, component, or part thereof that... Okay, now why do we have to be so careful with the definition here? What case is Congress concerned about that we read in this class about secondary liability? Sony, yes. What happened? What was the rule in Sony? Yeah, so the question is Sony guilty of contributory infringement? Because they are helping people break the law, right? All these customers who are library building are definitely breaking the law, and it's the Sony device that's doing it, and Sony is making a profit off all these people. Is Sony guilty of contributory infringement? And what's the answer?
No.
They didn't get in trouble, and why not?
Because they believe the majority of people weren't doing it.
Was it the majority? What's the phrase?
Substantial legal use for the device.
Substantial non-infringing use. That's the test. Substantial, maybe it's significant. Is it substantial? Substantial non-infringing use. So, of course, the consumer electronics people in this case were like, okay, if you're going to ban circumvention, don't ban the helping as long as there's a substantial, could they say non-infringing use? Is this about infringement, by the way? For instance, is there a fair use? Let's say you want to circumvent the DRM, but it's for the purpose of criticism or education or some sort of fair use. Can you circumvent then? Can you be like, oh, it's fair use, it's exempt?
Congress tells you can.
Yeah, but let's talk about fair use. Are the exceptions to infringement applicable here?
I think so.
Okay, well, let's look at what 1201 says about fair use. Okay, well, on fair use, they say nothing in this section shall affect rights, remedies, limitations, or defenses to copyright infringement, including fair use under Title 17. So you might look at that and you say, oh, great, fair use is still applicable as an exception. Would that be I defended this principle for like many weeks my freshman year, but would that be correct? I mean, nothing in this section shall affect rights, remedies, limitations, or defenses to copyright infringement, including fair use. So fair use is still there. What's the problem with this reasoning? Or that the court said was a problem with the reasoning?
Everything could have a substantial fair use. If all this illegal stuff for most people were useful for educational purposes, then...
So why does this 1201C1, why does this not immunize you as long as what you're doing is a fair use? You're not infringing. This is about copyright infringement, but what is 1201 about? 1201 is not about infringement. What does infringement mean? Exactly. It means trampling on the copyright, the exclusive rights of the copyright owner, which are reproduction and publication, reproduction and display and performance and derivative works, and the other one. Didn't I say that? Whatever. Yes, distribution. That's infringement. It's trampling on the copyright. But this section is not about copyright. It's this sort of para-copyright, and it's 1201. It's at least 600 sections away from the last wilderness of copyright. So this doesn't really help you, because they would say, well, we're not talking about copyright infringement. We're not even accusing you of copyright infringement. We're accusing you of circumventing something that is illegal by itself, sui generis. When this OpenCourseware is translated into Latin, they're going to have a lot of problems translating my use of that. But they're concerned. So Sony is like, well, we want to keep, this substantial non-infringing use doctrine around. We want to say you can still help people, distribute something that will help people circumvent as long as there's a substantial, what would you say, a substantial non-circumventing use? How would you say it? I mean, they're all going to be circumventing. How would you even explain it? What if you want to distribute a computer that obviously could be used for circumvention or it could be used not for circumvention? That you would still want to be okay. But how would you phrase this? If you were the technology industry, what would be your wish list for an exemption here? Not primarily used for what?
You don't advertise you used to do something that's bad?
I mean, okay, let's talk about DVDs. People know about DVDs, right? DVDs are encrypted. And the encryption key, and in fact the encryption method, they're kept secret. So you can get the DVD specification, which is that's also kept secret, but that's like $5,000 or something, or maybe it's $5,000 per volume. Anyway, it's expensive. You can get that and you can make a DVD drive, but that drive will be useless because you don't know the encryption. Or maybe you could make a DVD-ROM drive this way, but you couldn't play movies. So if you want to play movies, what do you have to do?
Get the secret key.
You have to get a secret key and you have to get the encryption method. So you go to the organization that controls it, which is basically the movie studios again, and you say, okay, please give me the secret key and the secret method. I'm going to make a DVD drive, but in exchange, what do you have to do? Yes, you have to pay, but what else?
Copy.
Non-disclosure.
Yes, a non-disclosure agreement. And you have to agree to all these restrictions. You can't let the people copy it. You can't let the people fast forward when the little FBI warning is coming up. People know this, like when sometimes the previous, you can't let them do that. What else can't you let them do? It used to be you could not give a progressive scan output because it would be too high quality and too easy to copy. And you can't ever send the bits out unencrypted. So if you want to put them over HDTV or something, you can't hook it up directly to your HDTV with the HDTV standard because HDTV is unencrypted, so therefore you can't ever send the bits out that way. So there's all these rules that you have to agree to. And so, and of course the algorithm itself has to remain a secret. So there can never be like a free software algorithm. So if you wanted to, let's say you're on Linux and you wanted to distribute a free software, an open source DVD player, can you do that? I mean, can you go to them and say, I'm going to distribute the open source DVD player that's going to have all the code? Will they be okay? No, why not? Yeah, I mean, they really want you to disguise how it works. And they realize that you could still pick it apart, but they say it has to be really disguised. You can't put the source code, and it can't be easy to modify. So if the user can just go in, and there's the part where, like, if it's during the FBI warning, you can't fast forward and just comment that part out, they're not going to let you do it. And the user could also just take the bits, instead of displaying them to the screen, could just save them, all sorts of things that they wouldn't want. You could play foreign movies. So they would never want to approve a sort of a free software Linux player. Now, but if you wanted to distribute this player on the grounds that, oh, it's just letting people watch the movies, and that's okay because they're just watching them, they're not doing anything bad. If there were a substantial non-infringing use standard, would you be okay? I mean, yes, because those people are not really infringing. But it's not. The standard is not substantial non-infringing use. And if it were, then the movie studios argue, well, you could just distribute this, all you wanted, and then people could get it, and then they could use it for their bad purposes. So the law is written much closer than that substantial non-infringing use standard. It says instead, you can't manufacture, import, offer to the public, provide, traffic in any technology, product, service, device, component, or part that A, is primarily designed or produced for the purpose of circumventing a technological measure, B, has only limited commercially significant purpose or use, or C, is marketed by the person or another acting in concert with that person's knowledge for use in circumventing a technological measure that effectively controls actions to work protected under this title. So I'm going to go over here. We're forbidding circumvention, and we're also forbidding sort of help to circumvention. And these are all in the access. This is all the access control column. Let's try this again. So we're forbidding circumvention of access control. That's the check means forbidden. And we're forbidding help for people who would circumvent access control. So we got them both. So that DVD player, it's, you know, you can't, even if you found out yourself how to make a DVD player, you couldn't distribute a device that would circumvent the access control. And that's what this whole Corley case was about. Now, part of it was about the First Amendment. It was about, can I publish source code under the, as speech under the First Amendment? And what did the court say? Did that argument carry the day? No, it didn't. Because the court said, well, this code, it's true that it's speech, but it's also functional. It performs a function. Now, did that stop DVD descramblers from being distributed? I mean, has anybody here ever watched a DVD with an illegal method? Like, okay, on Linux or on Windows or what? Oh, somebody on Windows, okay. I mean, I wonder if I can just get one right now. Let's see. I think I can do apt-get install libdvdc. Is that what I do? Yeah. Let's see if this will just work. Oh, no. Oh. Do I? I don't remember what it's called. Oh, okay. Apt-get install libdvdread3. Okay, there it is. Libdvd css2. I'm probably breaking the law right now. Anyway, so is this illegal, what I'm doing right now? Instructional use? What is that? Is there an exemption for instructional use? Face-to-face classroom teaching is an exemption to what? That's an exemption to infringement. But I'm not. But I wouldn't. The crime I'm committing here is not infringement. It's just.
Well, you're not really accessing.
You haven't used it to access anything yet, though.
What if you make a DVD at home? Are you allowed to do that and use this to play?
See, I can't actually install libdvd css2. I think I have to get that from Europe or something, the source of all illegal things. Okay. Well, that's good to know. Sorry, what was that?
Well, what if you make a home video DVDs?
My own DVDs.
Yeah, then should you be able to play it?
Yeah, if I have the, well, those wouldn't be encrypted. But if they were, I would have the authority of the copyright owner. So you're right. But I still couldn't distribute help that would help people circumvent the authority of some other copyright owner. But it's, and here's a guy at Carnegie Mellon who has he's tried to distribute all possible ways of expressing the code. This is me. But there's other people. Here's another member of SIPB, Charles Hannum, and here it is in standard ML and in something other than JavaScript. You got to be insane to use that. And here it is in Scheme and a GIF and some other language and English. And here's Omri Schwartz, another SIPB member in English. And not only is his in English, but he has an automated program for translating it back to C. So there's some very tricky First Amendment questions here. Here it is in a haiku by Seth Schoen, and here's a cryptanalysis. Here's a tie that has my code on it, and here's a dramatic reading set to music. Here's a song. You people have probably heard this song. Maybe you haven't.
What is this again?
This is all the code to descramble a DVD. This is sort of the code that was at issue in that Corley case, but expressed in different ways. Here's the logo of DVDs made out of the code to descramble DVDs. Okay, there's a lot of these. And I mean, has this guy gotten in trouble?
His
website's still up.
His what?
His website seems.
It's true, yeah. So, I mean, it's sort of a mixed result here in this DVD case, because in the law, the movie studios were entirely successful. They won on every claim before the court. They said it's not First Amendment. They said, first of all, this DVD descramble does circumvent a technological measure, which doesn't seem totally right. I mean, is it a technological measure, more of a anyway, it circumvents a technological measure, so it does break the law, and the law is constitutional, and it's not covered by any of the exemptions. And what else? Oh, and that they don't have the authority of the copyright owner. Now that has remained sort of mystifying to me, because you think when you buy the DVD, you have the authority to view it. But what the court said, what did the court say? I think I have some slides on this. Here we go. Oh, okay. Okay, so in the patent world, if let's say you buy something that's patented, you cannot make, use, or offer to sell the patented thing without authority, right? So if you buy a patented, what's something that's patented? I don't know. A what? Okay, a BlackBerry. Yeah, you can't make or use or offer to sell it without the permission of the patent owner. But of course, when you buy the thing, they can't then say 3 years later, oh, we revoke your authority because we don't like you. When you buy it, you also sort of buy the authority. And this case that I cite here, Rapido type stencil, says generally when a seller sells a product without restriction, it in effect promises the purchaser that in effect for the price, in exchange for the price paid, it will not interfere with the purchaser's full enjoyment of the product purchased. This full enjoyment has a lot of meaning there. The buyer has no, I mean, I'm serious. There's a whole case about full enjoyment. The buyer has an implied license under any patents of the seller that dominate the product or any uses of the product to which the parties might reasonably contemplate the product will be put. That seems like a pretty reasonable rule, right? Like if you buy the BlackBerry and later BlackBerry comes out with some other state-of-the-art thing that is newly patented that they want more money for, you can't like go in and modify your BlackBerry to do the new thing, infringing their new patent. That would be not okay. But anything that you reasonably could contemplate the original BlackBerry would be used for is fine. So you might use this argument. You say, look, when you buy the DVD, obviously you reasonably contemplate that I'm going to watch it. So I do have the authority, at least to watch it. But the court in... so the language for patents is, without authority, make, use, offer to sell, or sell. What's the language here is the same thing, to do it without the authority of the copyright owner. So the first one is don't use it without authority, and here's don't descramble without authority. And did the court agree with the sort of analogous argument that the same thing should apply in the DMCA world? No, here is, okay, so the scenario is you buy a DVD and you use, this is the entire algorithm that was in question in that case, in Perl. So, and then in this case, so I'm making this argument, I have the authority to view it, and what does the court say in response? It says I'm wrong. It says the appellants argue that an individual who buys a DVD has the authority of the copyright owner to view the DVD, yes, that's what I said, and therefore is exempted from the DMCA, pursuant to that section we're just reading, when the buyer circumvents an encryption technology in order to view the DVD on a competing platform, such as Linux. So that so far, that I think well summarizes our argument. And the court says we're wrong. The basic flaw in this argument is that it misreads what we were just reading. That provision exempts from liability those who would decrypt an encrypted DVD with the authority of the copyright owner, not those who would view a DVD with the authority of a copyright owner. Does anybody want to explain the difference?
So you can only view it legally?
But I mean, if you have the authority to view it, surely, I mean, that includes the authority to decrypt it, right?
Why?
Well, you have to decrypt it to view it.
When you view it, you just get the image on a screen. When you decrypt it, you get a bunch of files.
Okay. But what about when you use, Zine or MPlayer or one of these illegal programs, Ogle or Totem, to view it? Then you don't get files. Then you just watch it, right? Is that okay? Excuse me. Yeah, you're right. It's not. But I don't really understand where the parameters are here, because I just don't. And I wrote to Nimmer. I was like, "What's up?" And he's like, "Hey." I mean, he doesn't know the answer either. Now, then we read this garage door opener case, right? So anyway, just to sum up, what the copyright owners at least say is that you don't get the unrestricted authority to view and decrypt the DVD when you buy it. What you get is the authority to view it on a licensed device. They say, we license certain DVD players with our algorithm, and those are the ones on which you have the authority to decrypt it, not some other one like MPlayer or Zine or DCSS. That's what they say. Then along come these garage door opener people, the Sears Craftsman garage door opener, and there were no stated restrictions on what you're allowed to do. And the motor, are people taking 6115? No? Okay, well the motor is controlled by a PIC microprocessor, and it's got some copyrighted software on there, and when it receives the signal like open the garage door, it starts the motor, and then eventually it stops the motor. And the remote control is made by the same company, and they don't want, if you lose your remote control, they want you to buy the replacement from the same company, from Chamberlain. But this Taiwanese company, Skylink Technologies, don't underestimate, by the way, there's always like there's often a trade or international related component to these disputes. But the Taiwanese company figured out how to make their own replacement remote controls, presumably for cheaper. And Chamberlain was like, you got to ban these because they're accessing our copyrighted work, the software in the motor, without our permission. Because when we sell you the device, we're giving you the authority to access that software only with our garage door opener, but not with some other knockoff garage door opener. Just like we give you, the motion picture companies say, we give you the authority to watch the movie with our licensed DVD players, but not with some knockoff DVD players. And in fact, there is an encrypted signal, or sort of weakly encrypted, between the opener, the remote control, and the motor. So why are they wrong? She says, because it's not the same thing. Okay. Also maybe because Skylink hired David Nimmer to represent them.
You can hire him.
Yeah, he's just expensive. Actually, I don't know how much he is. If you're watching this, David, I'm not saying anything bad about you. Anyway, so the courts, this is not actually the court I'm citing here, it's the International Trade Commission. Oh, it's quoted by the court. They said, well, the fact that the Chamberlain did not give customers any warning about not using any unauthorized transmitters, because they say, well, we didn't do that because there weren't any unauthorized transmitters. And in fact, if you buy a DVD, has there always been a warning about don't use unauthorized DVD players? No, there's no warning. But they say because there were none at the time does not explain why Chamberlain has done nothing now that they know that there are transmitters that can be used with their garage door openers. So they sort of blame them for not updating the manual, which is sort of confusing because the customers who have already bought the thing should not be held responsible for what some later edition of the manual says. So, but Chamberlain took that very literally, and here's their manual, LiftMaster Professional Garage Door Opener. They took their manual, and on page, do I say what page it is? Here's page 2, and then here's page 31, and at the top of page 30, but if anybody gets to page 31 of their garage door opener manual, you get a special medal. But at the top of this, they say, notice, if this Security Plus garage door opener is operated with a non-rolling code transmitter, the technical measure in the receiver of the garage door opener, which provides security against code theft devices, will be circumvented. The owner of the copyright in the garage door opener does not authorize the purchaser or supplier of the non-rolling code transmitter to circumvent that technical measure. That's on page 31. So, yeah, so now it looks like they're in the clear, right? You've got clear warning that you're not authorized. That's a lot more than the DVD people get you. Right? The DVD people don't give you any notice. You just have to sort of know. But these people, they give you notice on page 31. So do people think they would win, that now they won the case? No, why not? Whoops, sorry. So here's their manual. Whoops. So that's their manual. Anyway, so they didn't win, right, anyway. And the decision was sort of about this authority, right? Yeah.
Traditionally, customers have been used to buying transmitters which are openers for all brands, and so
that's true.
They had reasonable expectation that when
it's about reasonable expectations. I mean, do you think that these two rulings are sort of in conflict? The first ruling came from the Second Circuit Court of Appeals. And where are they? In New York. The DVD one comes from New York. I think they control New York and maybe Connecticut. And this one comes from the Federal Circuit, which is, well, they don't really have an authority over anywhere. But anyway, but these rulings, there's not like a constitutional crisis if these two appeals courts disagree, but they do, in my opinion, sort of disagree about the proper scope of authority. And there's another case that we didn't read about, toner cartridges, sort of a similar thing. So I think there's still a lot of unresolved material here about the meaning of the precise contours of the Digital Millennium Copyright Act. But at least with the current status quo, the sort of more traditional copyright owners, the songwriters and the motion picture companies, have been successful in court in preventing anybody from sort of legally distributing these knockoff DVD players. But they've been totally unsuccessful, like in real life, doing that. And in fact, a lot of people just distribute them from like other countries where they don't have laws preventing it. So there's sort of a difference between the law and real life. And I wanted to add one other thing. If we look in the DMCA, there's a third provision. We ban circumventing the access control, and we ban helping with the access control. And they also ban, let me pull this up. Here's additional violations. No person shall manufacture, import, offer to the public, provide, or otherwise traffic in any technology, product, service, device, component, or part that is primarily designed, technological measure that effectively protects the right of a copyright owner. So what is this one about? It's not about access control. It's about what kind of control? Yeah, it's about copyright. And does it stop you from doing it or from helping with it? Yeah, from helping. So it's these three things that are forbidden by 1201. Why don't they forbid this one?
It's already covered, right?
Yeah.
It's already covered by what?
The rest of the copyright.
Yeah, exactly. This box is copyright infringement. So the fair use defenses and everything apply to this box, but they don't apply to any of these. And just as a quick question, does the DVD copy protection, or I already prejudiced the answer there, does the DVD content scramble system, the thing that case was about, is that copyright protection that would be covered by subsection B, or is it access control that would be covered by subsection A? I mean, they let you watch the movie all you want, right? It doesn't stop you from accessing it. It's not like pay $5 per time you watch it. Sort of the trick question. Well, that's true. It could be both. I mean, the problem is that this careful distinction that Congress spent all this effort on and debated and all this stuff, it's a distinction in law that doesn't really exist in real life. It's very hard to say. I mean, how would you could you even make a technological measure that didn't protect access but did stop you from copying? I mean, how would that even work?
You could copy it, but you copy and encrypt it. So that you can't read it, but you can make a copy of it.
Well, that would protect accessing but not copying. But I'm talking about the reverse. How would you stop them? If the guy can access it all he wants, how can you stop him from copying it? Well, so anyway, so this, the problem is that the law and real life often, it's not so easy to map them onto each other. And the problem, real life, keeps changing. So, if you look at the debate in Congress, it was not about DVDs. It was about these black boxes. And in fact, there's this whole question about, when they say authority, is that authority to block all access of a work? Or just initial access? Initial access would mean you decrypt the font and now you have the font. Or you pay for the cable channel and now you have it. But you could then send it to another TV in your home. Or is it every time you access it? And if you look at the floor statements of the Congress people, they make conflicting statements. One of them says, I'm really happy that we modified this bill to be clear to protect the rights of the consumer, that we will not have a pay-per-use society. If you read the David Nimmer paper, the legislative history of the DMCA, he talks about this in a lot. But he says we'll not have a pay-per-use society, and we will. It's only going to be about initial access. But in fact, the law was not changed when he said that. I mean, there's these conflicting statements about the meaning of the same law. So anyway, so it's confusing, and it's still not quite clear how to map real life onto the Copyright Act. But that's the DMCA. Does anybody have any questions about copyright or the DMCA or anything else that we can answer at the end? Michael?
Hi.
Oh, no? Okay. Oh, yeah.
I have something to add because it's really funny. It's about DVD protection in France. Because in France, the law is slightly different. You have every consumer has the right to make one personal copy for any kind of copyrighted device, either book or DVD, and the DVD protection forbid you to do this. So just this year, the Court of Appeal of Paris has issued a ruling banning the DVD protection from the DVD of Mulholland Drive.
Is that a movie?
Yeah.
Okay. Oh, Mulholland Drive. Okay. Bill, because it doesn't let you make a copy? Now, isn't this true of every DVD?
Oh, yeah, but
why do they go after Mulholland? I mean, I'm not saying it's a bad movie, but why Mulholland Drive?
Just because one consumer sued the movie company for about this one, but it would apply for every DVD in France.
Well, that's
or even in Europe, because this is a European recognized right.
Well, yeah, it'll be interesting to see what France ends up doing. I wanted to close. Sorry.
Basically, they don't have any more right to sell any Mulholland Drive DVD with the protection.
Did they take it off, or what did they do? I hope that the French people are not deprived of Mulholland Drive. I wanted to close with this sentiment, which is my sentiment, which is that the job of all of you should be to be experts both in real life, and by real life I mean technology, what we teach at MIT, and also public policy and the law. Because we have this real disconnect between sort of people who are in public policy and copyright and another kind of real life, and people who are in technology. And it's hard to find people around here who think that copyright should be strengthened. Is anybody in this class of that mode of thought? Does anybody think copyright, there should be more restrictions? Or it should last longer? Nobody here. But in Congress, the situation is reversed. And obviously in Hollywood, is widespread opinion that copyright is too weak, and technology people are just, we're going to bankrupt the copyright owners. And it's a complete reversal, and similarly unanimous opinion. And I think this really is bad, because when you have these big groups and they don't talk to each other and they don't understand each other, you don't end up with you don't have communication. It's not really to anybody's advantage. And I interviewed Jack Valenti when he was at MIT in 2004, and I say, the broadcast flag, I object to it because it means we haven't talked about the broadcast flag, but it's a similar DRM mechanism. It would stop you from building your own TV set, was my argument. And he says, well, how many people build their own sets? I mean, seriously. And he says, the broadcast flag, if you're in your own home, you can copy anything that's on television to your heart's content. The only time you will know there's a broadcast flag is if you try to take one of those copies and redistribute it on the internet. Then the flag says, no, you can't redistribute it, but you can do everything you're doing right now. You'll never know there's a broadcast flag. Well, why would people object to it? The problem is that Mr. Valenti is just wrong. No DRM could work that way, at least not now, because if they let you distribute it within your own home, like iTunes does, they will inexorably let you redistribute it on the internet, as iTunes does. The technology just doesn't exist. And I think if you guys all graduate and go work for technology companies and you start saying, we have this awesome technology that will let you control exactly what your works can do and can't do, well, shame on you. because you should not misrepresent what science and technology do in the service of, you shouldn't misrepresent it, because it leads to these sort of public policy confusions and people thinking that they can demand things that don't exist. So I charge you with the job of integrating the worlds of public policy and technology and ensuring that we don't have this disconnect anymore. And so go forth. Thank you.